Good morning, good afternoon, good evening, everyone. A very warm welcome to all our attendees joining us today from across the globe. On behalf of International Intellectual Property Law Association, I'm delighted to welcome you to today's webinar on highly relevant and forward-looking topic AI, Big Data, and IP protection. As technology continues to evolve at a rapid pace, understanding how artificial intelligence and big data intersect with intellectual property right has become more important than ever for businesses, legal professionals, and innovators alike. Before we begin, a quick reminder, if you have any question during the session, please feel free to drop them in the chat box. We will address them during the question and answer segment at the end. It is now my pleasure to introduce our esteemed speaker for today's session. We are honored to have Ms. Lorraine Lu with us, an accomplished associate at Beijing Zhongglun law firm from China, Hangzhou. Ms. Lu specializes in intellectual property law, artificial intelligence, data compliance, and open source compliance, making her expertise highly relevant to today's topic. She is an active member of leading professional bodies including LES China and Intellectual Property Law Society of China Law Society. She also serves as member and rotating chair of the Young Lawyers Committee at her firm's Hangzhou office. In addition, she has contributed to global legal initiative, including being part of the preparatory committee for a WIPO-hosted webinar on IP and sustainability. Ms. Liu is admitted to practice before all PRC courts and hold multiple professional qualifications, including trademark agent, copyright agent, fund practitioner, and securities representatives. Her journey includes experience with prestigious organizations such as King & Wood Meissen Shanghai, Alibaba Group Headquarters, Denters, and multiple Bureau of Justice. She also advised across diverse sectors including renewable energy, medical devices, fund management, and Fortune 100 multinational companies. With such a dynamic and accomplished background, we are truly privileged to have her with us today. So without further delay, I would like to invite Miss Lauren Liu to take the virtual stage. Lauren, the floor is all yours.
Thank you for the boarding team and organizer. Now it's my turn. A warm welcome to all of you joining from across the globe. My name is Lauren Lu, and on behalf of the organizing team and myself, I want to extend a very sincere and heartfelt welcome to each of you. I want to begin by expressing my deep appreciation to the organizing committee for their extraordinary dedication in putting this webinar together. I am grateful for the invitation, and I hope to honor it with the quality of the discussion we have today. What we are doing today is a professional preview, a focused substantive preview of the themes that will be developed more fully at the IIPLA annual conference in June 2026. Today, I will take you through the analytical framework and the key questions. Where my analysis is based on Chinese law or Chinese market practice, I will make that clear. For everything else, I am speaking from a general cross-jurisdictional perspective. Let us begin. Today's webinar is organized around 8 themes: AI and IP landscape, the legal frontier, patentability of AI-related innovations, AIGC copyright, who owns AI-generated content, brand enforcement in the digital age, cross-border e-commerce and SID litigation, AI large models, global jurisdiction battles, international conflicts, landmark cases, and finally, a risk management framework and takeaways. Before we proceed, allow me just to briefly introduce myself. I'm a lead associate in intellectual property part at John Law Firm now. I remain student of these frontier issues about AI compliance, data compliance, and intellectual property protection. And I look forward to further exchange ideas with all of you at the in-person annual conference in June. Let me start with the macro picture. All the specific issues we will discuss today, whether patents, copyright, or compliance, are driven by a small number of deep structural tensions. The tensions remain constant. What changes is how they manifest. Tension 1. Data sovereignty versus cross-border data flow. We live in an area of competing data sovereignty claims. The EU GDPRs and the US Cloud Act and China's PIPO and the data security law all have extreme extraterritorial reach, meaning each applies its own standards and enforcement mechanisms to data regardless of where the data is processed or stored. As a result, a large language model serving users across multiple jurisdictions may be subject to three or more conflicting legal regimes at the same time, which is a current operational reality for AI developers and deployers. Tension 2. AI creativity versus human authorship requirements. Major copyright frameworks, including the Berlin Convention, TRIPS Agreement, and WIPO Copyright Treaty, were built on the assumption that authors are human beings. None of these instruments contemplate a software system producing a protectable work without human direction at the moment of creation. As a result, courts and legislators are forced to interpret frameworks never designed for this situation, producing inconsistent results across jurisdictions, as we will see on slide 6. Tension 3. Territorial IP law versus borderless AI technology. Intellectual property rights are territorial by design. A CNIPA patent protects inventions within China. A U.S. trademark registration covers the United States, and an EU trademark covers the internal market. This architecture was built for physical goods and localized services. Generative AI has no geographical footprint. It runs on distributed infrastructures, trains on global data, and serves users everywhere. When such a model infringes IP or processes data unlawfully, existing frameworks offer no clear answer on which law applies or which court has jurisdiction. Tension 4. Open source licensing versus proprietary IP control. Open source LLMs such as Meta's Llama, Alibaba 2021, and DeepSeek are released under both standard licenses like Apache 2.0 and MIT. The bespoke community licenses with extra restrictions. Many of these custom licenses include jurisdiction clauses, use restrictions, and attribution requirements that create compliance risks for downstream users. This is not widely understood, and I will address it on slide 12. Now, I want to approach patentability of AI-related innovations from the angle what can be patented. Under China's patent law, Article 22 and 25 exclude rules and methods of mental activities, methods for the diagnosis or treatment of disease, and animal and plant varieties from patentability. The CIIP's 2024 revised examination guidelines clarifies that an AI-assisted invention may be patentable if it solves a technical problem using technical means to achieve a technical effect. The three-pronged technical character requirement. Mere mathematical algorithms or abstract AI rules as such remain unpatentable. In the EPO, the position follows a similar technical character requirement derived from the European Patent Convention Article 52, which excludes programs for computers, mental acts, and mathematical methods as such. The key word is as such. An AI-related invention can be patentable if it produces a technical effect going beyond the normal physical interactions between the program and the computer on which it runs. And in the US, the post-Alice landscape continues to present challenges for AI-related claims. Under the Mayo-Alice framework, abstract ideas, including mathematical concepts and certain AI algorithms, are not patentable unless the claims contain an inventive concept that amounts to significantly more than the abstract idea itself. However, in November 25, the USPTO design expertise discharged as a presidential decision, marking a significant shift. AI technologies that improve the operation of machine learning models themselves, such as enabling continual learning or reducing storage requirements, are now eligible for patent protection. That said, two boundaries remain. First, obviousness under Section 103 is still an independent threshold. Second, USPTO allowance does not guarantee that a court will not invalidate the patent under Section 101. Let me turn to what I consider the most actively contested question in IP law today. Who, if anyone, owns copyright in content generated by AI? This is not an abstract philosophical question. Every organization that deploys a generative AI system needs a clear answer. If your AI generated a marketing campaign, a legal brief, or product design, or a piece of software code, do you own it? Can you license it? Can you enforce it against infringers? The answer differs by jurisdiction, and in some jurisdictions, the answer is currently no. Step 1, is AIGC a protectable work? Before we discuss ownership, we must address whether AI-generated content can constitute a copyrightable work at all. The threshold requirement in most framework is some form of originality rooted in human intellectual creation. Now, from the perspective of Chinese law, under China's copyright law, Article 3 defines works as intellectual creation in literary, artistic, or scientific domain that are original and can be reproduced in a tangible form. Article 11 provides that copyright belongs to the author and that the author is the natural person or legal entity whose name appears on the work. The question of whether pure AI output without meaningful human creative contribution can constitute a work remains unsettled under Chinese law, with courts reaching different conclusions now. And step 2, if AIGC can be a work, who owns it? Assuming AIGC can be protectable for types of claimants may claim ownership, the AI system itself, the user, the developer, and the investor. Our 2024 research analysis which of these are recognized as copyright owners across major jurisdictions. AI users, developers, and investors may each qualify as copyright owners. depending on the degree and the nature of their creative contribution. And we do not advocate for recognizing AI as a copyright subject at this time, as this would require a fundamental revision of the author as human principle that underpins existing frameworks. Below are several representative cases that illustrate the evolving judicial approaches to AI-generated content and liability. Two cases are in China. Case 1 is Beijing International Court 2023, the AI image copyright first case. In November 2023, the Beijing Internet Court ruled that a user who generated an image using Stable Diffusion by crafting prompts and selecting from outputs held copyright in the resulting image. The court found that the user's intellectual choices in prompting and selection provided sufficient human creativity, even though the AI handled the pixel-level work. This was the world's first ruling affirming user copyright in an AI-generated image. And case 2 is a Guangzhou Internet Court case. In another case, the Guangzhou International Court ruled on AI platform liability. An AI service generated unauthorized images of Ultraman, an image, a copyrighted character owned by a third party. The court found the platform liable for infringing the rights holders' reproduction and adaptation rights. The key takeaway is that the AI developer bears direct liability for building and deploying a system capable of generating infringing outputs of non-copyrighted works. And the third case is a U.S. case between Tyler and Perlmutter. In the United States, the District Court for the District of Columbia affirmed the Copyright Office's refusal to restrict a work generated entirely by an AI system without any human creative input. The court held that human authorship is a prerequisite for copyright protection under U.S. copyright law. Works that receive copyright protection in China may not be registrable or enforceable in the United States. Consider the example of a Chinese company that faced a trademark opposition when entering the U.S. market. You can say that it is a famous Chinese company, and when they come into the market in U.S., they are opposed for some reasons. The first reason is that the likelihood of confusion, and the second reason is dilution. This is not an isolated incident, but rather a classic illustration of the principle of territoriality in trademark law, a challenge that any brand from any country may encounter when entering another jurisdiction. A mark securely protected in the country of origin may face prior use or prior registration obstacles. So it's very important for those corporates to protect their trademarks in other areas. In the first half of 2025, China's cross-border e-commerce import-export volume rose 10.3% year-on-year, outpacing overall trade growth. Yet many of the companies driving this growth face a type of U.S. federal litigation that makes it extremely difficult to assert defenses. This mechanism, known as the Schedule A Defendants (SAD) scheme, a term coined by Professor Eric Gorman of Santa Clara University School of Law, in the Columbia Law Review article operates as follows. And we find that the Schedule A defendants, we find that a lot of defendants are Chinese small or medium corporates who are operating the e-commerce related works, and they are being paneled in the cases. So it will be a big problem for those foreign countries to deal with. However, in 2025, there is a reform in a small reform in SAD. Responses to the SAD mechanisms are emerging at three levels. The first level is judicial level, the second is platform level, and the third is government level. For the first one, recent court rulings offer meaningful corrections but fail to resolve structural issues. Courts still lack a systematic way to identify misjoined defendants in advance, and the information asymmetry between plaintiffs and defendants at the TRO stage remains unaddressed. And the platform level, Amazon's 2025 policy updates strengthen evidence requirements before account freezes, mandate AAA arbitration for IP disputes, and establish a small claims settled fund. These are meaningful improvements, though their real-world efficiency remains to be seen. And for the government level, China's Ministry of Commerce plans to engage in international standard setting for cross-border civil procedure, aiming to shape the rules governing how Chinese defendants are treated in foreign courts. For the slide 11, the deployment of large language models at global scale has created what I describe as an overlapping jurisdiction problem, a situation in which multiple legal systems simultaneously assert authority over the same AI service, the same data, and the same conduct, under frameworks that were not designed to interact with each other. And we can see there are some regulatory contests. EU AI Act, Cloud Act, they all have different jurisdictions, clauses, and different obligations in those regulations and in those regulations. And for the OpenAI litigation cluster as a case study, the litigation involving OpenAI in U.S. courts provides the clearest available illustration of the scale of legal exposure of AI platform operators. The judicial panel on multiple district litigation has consolidated multiple cases in the Southern District of New York under docket number 125 MD 03143, joined together copyright infringement claims from new organizations including the New York Times, class actions from authors and creators, DMCA, Section 1202, claims for alleged removal of copyright management information and privacy claims under California state law. One overlapped legal risk in AI deployment is the jurisdiction clause in user agreements and open source licenses. Our 2025 review of 6 major models found that for the OpenAI, California courts is the jurisdicted court, and its mandatory NAM arbitration and class action waiver for individual users. And for the llama, exclusive jurisdiction in Santa Clara County, California. California law applies. And for those Chinese LM tours like Alibaba DeepSeek, Alibaba jurisdiction court is Hangzhou People's Court, and DeepSeek's court is at DeepSeek's location in Hangzhou. So there are some conflicts with the models because AI is widely used over the world. So those jurisdictions may have some problem when the foreigner use the tour, how to regulate it. So we think enterprises can often negotiate these terms. Individual users usually cannot. So for those individual users, it may be a bad term for them. For the slide 13, based on our research and practical experience, we propose organizing corporate IP risk management in the AI and cross-border contexts around three phases that correspond to a company's journey through a market or technology cycle. Phase 1 is very important, pre-entry. Entry, know before you go. Before entering a foreign market or deploying an AI system, a company should conduct trademark availability search in all target jurisdictions and freedom to operate analysis for core technology components, IP due diligence on suppliers and technology partners, including audit of AI model licenses and their downstream restrictions, and review of applicable AI regulatory requirements in target jurisdictions, including registration and security assessment obligations. Phase 2 is about operational embedded compliance in the business. IP compliance must be embedded in product development pipelines, supply chain management, and marketing process, not consolidated in a legal function. And phase 3, dispute response, act immediately and strategically. When litigation or enforcement arises, a when, not if, scenario for cross-border e-commerce or multi-jurisdiction AI deployment, AI immediately engage local counsel, assess any TRO or freeze order, and grounds to challenge it. For this slide 4 is about some research. It is some research that our team has done for between 2023 to 2026. There are some publications about the analysis of 100 cases and some standards, national standards like TCC42 and TCCC46. Here is 5 imperatives for practitioners. As we close today's session, I leave cross-border business with 5 imperatives. First, register for those companies, especially those cross-border companies, register your and your client's IP assets early in every target market before entry. Delay the following invites being blocked or held hostage. Use the major protocol proactively. Second, build a jurisdiction-specific IP strategy for AI-generated content. Copyright rules on AIGC differ sharply between China, US, and other countries. Audit every AI existed opted for cross-jurisdictional IP status. Third, rate the AI model license agreements you deploy, jurisdiction, and use registration clauses carry real legal consequence, including in custom community licenses for major open source models. Fourth, understanding the AD litigation risk if you operate cross-border e-commerce. Reference are positive, but structural risk remains. Proactive IP clearance documentation and emergency protocols are essential. And fifth, maintain legal intelligence monitoring as an operational function. Check the EU AI Act, IIPLA guidelines, US case law on AI copyright, and the SAD litigation reform through 2025 to 2026. Staying current gives you a sharp competitive edge over those caught off guard. Ladies and gentlemen, I want to close by returning to where I began with gratitude. To the organizing committee, thank you for your professionalism and care in putting this event together. For the audience, thank you for your time and attention. I think IIPLA in the age of AI is genuinely difficult, not because it requires obscure knowledge, but because it demands holding multiple frameworks in mind, tolerating uncertainty and advising clients confidently despite it. I look forward to seeing many of you at the IIPLA annual conference in June 2026, where we will have the opportunity to go deeper into several of these things in the company of some of the most distinguished IP practitioners in the world. I hope today's session has provided a useful foundation for those conversations. Thank you.
Thank you. Thank you so much, Ms. Liu, for that insightful and engaging session on AI, big data, and IP protection. Certainly, your perspective has helped us better understanding the evolving relationship between technology and intellectual property. Now we'll move to question and answer session. So I request all the participants to kindly share their question in the chat box. Well, Lauren, so we received hi and thank you for your presentation from Miss Nancy, and Tipton is also saying thank you. And of course, Nekili is transcribing your call. So might be like many of the participants is interested in your presentation. So certainly we will share you the presentation and everything post webinar, maybe like today or tomorrow, and the recording too.
Boris?
Well, yes. Do you have any question, S19 Max? All right, Lauren. So Lauren is one of the panelist member and the speaker in upcoming IIPLA 2026 China, which is going to held on June 8 and 9. So whosoever is interested to meet her and want to have a more detailed discussion, then they can register soon by opting or by getting the discount of webinar 100 on IIPLA page. Once again, I thanks to Miss Lauren for sharing valuable time and expertise. A big thank you to all participants for joining us and making this session a success. Have a wonderful day, and soon we will share you the recording of webinar and summary. Thank you, Lauren.
Thank you.